Did you find my YouTube channel?
I did, yeah.
Ah, look, this time it went through right away. So, okay, I can see that it's
Okay.
working.
Yeah, I checked it. It said you were streaming.
Yeah, it did, but it didn't come up. The last time, it hung up on that one screen.
Huh.
Okay. Shannon, put us back on the record.
Okay.
Tanner versus Tanner.
Good morning, Your Honor. I did reach Shelley Dungan. She was had the understanding that the court was going to initiate the call based on a conversation from earlier in the week or last week because of the connectivity issue or audio quality issue that she experienced last week with the court.
Oh, okay.
But, she's going to participate by phone. I spoke with her. She was ready at 8:30, but thought the court was going to initiate the call and not give them.
Yeah, I didn't. Unless I've got a note on the file that tells me that. That's not the kind of stuff I would ever remember. Let me see. All I have for her is an office number. Do you know if she's in the office?
She's going to be participating by her cell number, Your Honor, and she's going to. I think she's going to call in. She's got the meeting ID number and password. So I don't know if she's on.
Okay. I've got two cell phones in there. I'll check and see if which one is Shelley. Ms. Duncan, are you there?
Yes, I am.
All right. Okay, and I've got, I think, Mr. Navarre's client. Is your client participating? Do you know, Ms. Duncan?
He's available. He's currently driving back.
He doesn't have
if we need him.
No, I don't. I just I like to let the parties in when they're in the waiting room. I've got several unidentified. I've got a daddy's iPhone and a Galaxy S9, and so I won't worry about it.
No, unless you had questions for him, then I can just proceed.
No, that's fine.
Okay.
So we're here on objections to the temporary order. Is that correct?
Yes, Your Honor.
That is correct, Your Honor.
And it looks like I had objections from both sides.
That's correct, Your Honor.
Yes.
All right. Are these the type of objections I'm going to be able to resolve at a motion hearing, or are we going to have to do something more than that?
Your Honor, I think that would be something that would be required for you to make a factual determination, because it's our position that the support guidelines, their position is they weren't calculated correctly. Our position is that you're going to need to do a deviation if we can't agree to a deviation upward anyway because of the party's unique circumstances. And so that would require a specific factual determination by Your Honor. I am optimistic that through counsel, the parties can come to a consent agreement as to a support amount, and then we can, for additional, to address additional financial concerns of the marital estate or otherwise, we could be able to reach an agreement. But absent that, I would like at least a hearing date for the parties, so we have some kind of a control, and then if we're able to reach a mutual agreement and get a consent order entered, we can remove that date and not clog up Your Honor's docket.
What would be a realistic time frame? 2 or 3 weeks?
Sure.
Yeah, I think so. Somewhere in that range,
Well,
Your Honor.
I'll write a note to Dawn. I'll write a note to Dawn. She's out today. ask her to find you a date within the next 2 to 3 weeks, clear it with both of you. In the meantime, you can work towards resolution. If you can't resolve it, I'm happy to address whatever it is that you're unable to resolve.
Thank you, Your Honor.
Thank you, Your Honor.
Is that agreeable with you, Shelley?
That's fine. I just looked at it differently, but if you want, you want a deviation upward, then that is something the judge would have to do. I just wanted it sent back to FOC for a recalculation. I think we're just quibbling, Judge, over what we're calling things. I would just like, the support to be run at just calculated at guideline, and then these other things, these other extra supports we need to put in place. They're basically some contribution to marital debt and some special services and things like that. I just kind of want things labeled what they are. My guy has no qualms with supporting his child and his wife, and he's very generous. So I just want things to be called what they are. I don't think that's.
I don't think my client has an
distinction.
objection for the matter to be recalculated if he can provide the documentation regarding his per diem expenses.
Yeah, because I don't think that would be a problem. I just thought it'd be easier just to, send it back and then we'll hash out the other stuff. But if that's what we want to do, it wouldn't hurt to have another hearing set up so we know what we're doing and we've got a deadline. So that's fine.
All right, I'll have Don get with both of you and give you a date.
Thank you,
And
Judge.
as it relates to sending it back to the front of the court for recalculation, Your Honor,
Did you want me to do that? I was under the impression you did not.
I mean, I don't, if there was an error in the calculations, I don't have an issue with it being recalculated, so that at least there's a baseline that we know what the manual would require and that you otherwise would have to follow unless there's a deviation. And so I think that probably would be appropriate for a baseline to be properly established. And then if there is a deviation, then we know how much it is and what direction it's going.
And if I'm going to send it back for a recalculation, what instructions should I give them as to whatever the mistake was?
Thank
Well, I
you,
think it
Judge.
should.
That would.
Go ahead, Shelley.
No, I think that what they did was imputed his wage, his 80-hour-a-week wage to him over the 3 to 4 months that he is off every year. It's a mandatory layoff. He's not underemployed. He's not voluntarily unemployed during that time. So it was my contention that he should not be imputed that income and that they should use his income, but they should also use the unemployment he receives. And also he was imputed the per diem in that mandatory layoff period, which shouldn't be done. And also the per diem is pretty much spent, but they included all of the per diem income, and that's the income he lives on, rents, an apartment with, or has to stay in a hotel with, his food, his whatever he needs for his job, uniforms, those kinds of things. So that's spent. So that was imputed 100% to him as well. So I know it's a lot of stuff, but for it to be fair, those things shouldn't have been included. That's my contention.
So I can direct the friend of the court to recalculate without imputing income and without imputing the per diem income. And then at least that gives you a baseline to work from. That doesn't necessarily mean that Mr. Navarre would agree that those things shouldn't be taken into account in some fashion, but at least gives you a baseline to work with. Does that make sense?
I think that our position is that he did not provide documentation to the friend of the court regarding his per diem expenses. And the manual requires in 2.01M for the support to be based on what is allowed in Michigan only, and not additional expense if you don't provide the documentation. So as it relates to the per diem amount, I think that the order should require the specialist at the front of the court to take into consideration, if he provides the documentation, she has to take that into consideration. Otherwise, the standard rates allowed by the state of Michigan for employee travel, including per diem and mileage, have to be utilized. And my understanding of the way she calculated it is that she did use the Michigan standard rates. But in any event, if he provides the documentation, then she has the authority in the manual to utilize additional per diem expense and label it and consider it as such.
Well, and it's tough, Judge, because you're talking about things that, money already spent, things that weren't saved, hotel receipts, food receipts, receipts for, uniforms, new boots, things like that, not knowing that you have to provide those things, but knowing that it's common sense that he had to stay somewhere and that he spent the majority of that money. He didn't pocket it. He had to live on that. So that's what's really difficult here. And I didn't know what would be fair, because there's no way that he can provide, oh gosh, I got this meal, 6 months ago or what have you, to add that up. But it's also, that money isn't there and isn't pocketed. So I couldn't, I read the same thing, but I don't know how you expect somebody to do something like that. That's where we're at.
I got you. So what you're saying is his employer doesn't require him to account for how he spends the per diem, doesn't require him to submit mileage reports, expense reports, anything of the like. They've just estimated this is what we believe is a reasonable amount to cover your expenses when you're on the road.
Yep.
Well,
I know.
obviously that does get challenging. How often is he on the road?
That's pretty much 9 months out of the year, 8 months out of the year. Like he's on his way back from Louisiana right now, for example. And he just said, sometimes I stay in a hotel, sometimes I can find an apartment. If I'm going to be down there for a month, sometimes I have to pay a lot more than I've got for an apartment. It just depends what he can procure for himself, depending on where he is. But yeah, he's constantly on the road and out of state.
So if I send it back for them to calculate his per diem, and he doesn't have receipts, is that going to get us anywhere?
I think it gives us an opportunity, if you send it to the front of the court, for them to recalculate and maybe have a facilitative conference. It provides us with an opportunity to agree and stipulate on a support amount.
Well, this would be my proposal. So if we run it with his actual income and his unemployment, then let's run it with the per diem, of course not in the imputed period, and run him with the per diem and without the per diem. And I think somewhere in there to see what it translates to in actual child support dollars and compare them, maybe. That might be helpful. Just as long as we're not imputing anything to him.
I think that is an excellent idea.
So I'm going to order that referral back to the front of the court with the language that you just suggested, Ms. Dungan. If you could put that in an order and submit that, and we'll make sure that that gets sent over to the front of the court. And then I will tell Dawn, this shouldn't take very long for them to do. Can you put in the order that the front of the court is to consult with both attorneys?
Sure.
In preparing the calculation and get your input?
Sounds good. Just jotting all this down. Okay.
Okay. And then
Sounds
all
good.
I'll give Dawn is a note to give you a date about 3 weeks out to make sure all of that can take place.
Sounds great, Judge. Thank you for your time.
Thank you,
You're
Your
welcome.
Honor. That concludes my matter. Have a good day, Your Honor. Thank you, Sally.
You
Thank you, Sean.
likewise.
Thank you. Thank you.
All right, let me call up Aldrich.
What's going on with the other 830s?
I don't know, they disappeared. Oh, wrong Sean. I think
Can you hear me, Judge?
I can.
Sorry about that. I'm just pulling it up here. There we go. How you doing today?
Good. Are we going to do a standard council only pretrial?
Judge, we've got the parties here. I believe we have an agreement, so we just need to do a pro-con. I emailed the judgment to Mr. Campbell, and I'd suggest leaving the trial date, which I think is the 13th, on just to make sure you get the judgment, but it looks like we've got it all resolved.
I'm
Okay.
sorry, what case is this?
This is Aldrich versus Aldrich, Shannon.
Okay, who's here?
Ms. Denke for the plaintiff. Mr.
Campbell.
Sean Campbell
That's correct, Your Honor.
for the defendant. Ms. Aldrich, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your full name for the record.
Heather Paulina Aldrich.
Go ahead, Ms. Denke.
We filed a complaint for divorce in this case. Was everything in the complaint for divorce true at the time that we filed it?
Yes,
And does it remain true today?
yes,
And we've addressed all of your living minor children in the judgment of divorce.
yes,
Is there any possibility that you're pregnant today?
no,
Has there been a breakdown in the marriage such that the two of you will not be reconciled?
yes,
And you have been actively participating in the negotiations for the judgment of divorce?
yes,
And once it's presented to the judge, you're requesting that he sign it?
yes.
Thank you. I don't have any further questions.
I'm satisfied based on the proofs there's been a breakdown in the marriage. To the extent the objects of matrimony have been destroyed, there remains a reasonable likelihood the marriage can be preserved. I will sign that consent judgment of divorce upon presentment. We'll turn the trial date into a status conference as long as we have a judgment of divorce by that time. There will be no need to appear. Thank you, counsel.
Thank you.
Thank you. Have a good day.
We're all set, Heather.
Likewise.
All right, thank you.
Okay, next up, it looks like Macomber versus Macomber. I don't see Mr. Fallahy. Let me check in with Mr. McGivney. Good morning, Mr. McGivney.
Morning, Judge. How are you?
I am fine, thank you. Mr. Fallahy isn't here at the moment. My guess he's probably in another court. Let me deal with another pretrial that we don't have attorneys on. And I'll put you back in the waiting room. Eventually, we might, if I finish the other stuff, just close this session and do that in chambers.
That's fine. Great.
All right, I'll put you back in the waiting room.
Thank you, Judge.
You're welcome. Okay, next up. Boobier versus Boobier. And I don't have them in by name. I'm just going to have to figure out. I think I'll just let everybody in. That might be easier.
Hello.
Good morning.
Hey.
Good morning. I decided to let everybody in because it was easier. If you've got a YouTube running, please mute that. So I'm looking for James Boobier and Jessica Boobier. Are you guys present?
I am.
Yes.
All right. I'm going to name so I know who's who. All right. And I'm going to put everybody else back in the waiting room. Okay. So I have a proposed, and Shannon, Jessica Boobier and James Boobier are both present.
Great, thank you.
I've got a proposed judgment of divorce. Is that something both of you have gone over and agreed upon?
Yes, Your Honor.
All right. My secretary retyped that just because there were some issues with what was submitted, but didn't change the substance. I'm going to go through that quickly with both of you just to make sure we've got everything in here that you intended. Neither one of you is seeking spousal support? Correct?
Correct.
You wish that beneficiary rights in annuities, life insurance, endowments, etc., be addressed elsewhere in the agreement, as well as pension rights to be addressed elsewhere in the agreement? And we'll get to those details.
Yes, Your
You
Honor,
each-
I'm sorry to interrupt. I'm sorry to interrupt you. I'm just getting a text from James, and he's saying that he got put back in the waiting room.
Oh, I relabeled the wrong one. I'm sorry. You know, the problem is these little windows jump around on my screen. and I didn't happen to
Sure.
notice that it must have jumped. Let me rename this so I don't have the wrong person there.
Okay.
Someone's in currently by telephone. Could you state your name, please? Well, whoever it is can't seem to hear me. So we'll put him back in under unknown. Thank you, ma'am, for interrupting me. I appreciate it.
Yes, I apologize.
No problem. But I don't know which one.
I
is
believe-
him.
I believe his screen name said Daddy's iPhone.
Oh, okay.
There we
All
go.
right. Sorry about that, sir. Okay.
That's okay.
Let me go back through this. My secretary had to retype your proposed judgment of divorce, but I want to make sure it's got everything in it that you both want, okay?
Sure.
Neither one of you are seeking spousal support. Beneficiary rights and pension rights are addressed at the end of the document. You're each going to keep whatever's personal property is in your possession. Real estate is addressed at the end, and I'll get to that. It looks like you're going to use the provisions in the temporary order regarding custody, parenting time, and child support. Is that correct?
Correct.
Correct.
Okay. Payment will be routed through the friend of the court. She did spell out the visitation schedule. So plaintiff gets alternate weekends plus every Tuesday and Thursday, and holiday, Christmas break, and summer parenting time as the parties can agree. Is that correct?
That's correct.
Correct.
Okay, and then let's see, defendants refinancing the marital home after 6 months. Defendant is going to be responsible for the Chase credit card debt. Plaintiff is going to be responsible for paying back a loan of $9,869.72 to defendant's 401k. Defendant's going to receive $17,993.01 from plaintiff's retirement account. And you do understand that requires a very special kind of order. We call it a quadro. Has anybody explained that to you?
No, Your Honor.
No.
All right. He can't just simply give you, I'm sorry, you can't simply give him money from your retirement account. What you have to do, and there's a company that does this, I think it's called QDRO Express.
Okay.
And for a fee, they will prepare for you the kind of order that, ma'am, your employer is going to require, or whoever administers your retirement plan is going to require, before they will make any kind of a distribution from that. It has to be done. It doesn't look like you've addressed that here, but that's the only way that can happen, is with a quadro.
Okay.
There's a cost for doing that. Normally, that is shared. I mean, it doesn't have to be, but it's often shared. So plaintiff's going to remain a beneficiary on defendant's primary life insurance until June 1 of 26. And after that, looks like the children are going to be made beneficiaries. Similarly, defendant will remain as plaintiff's primary beneficiary until that same date, at which time the children will become the beneficiaries. That's all stuff that you've already agreed on?
Yes, Your Honor.
Yes.
All right. And you both believe all of those provisions are fair and equitable under the circumstances and in the best interest of your minor children?
Yes, Your Honor.
I do, sir.
Okay. Ma'am, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name, please.
Jessica Taylor Boubier.
Ms. Boubier, you filed a complaint for divorce back in January of this year. Was everything in that complaint for divorce true at the time that you filed it?
Yes, Your Honor.
And is it still true today?
Yes.
It appears that during your marriage to Mr. Boubier, you had 2 children, James, they're twins, James and Emmerich, both born on May 22nd of 2008.
Yes.
Did you have any other children during your marriage that are not Mr. Boubier's?
No.
Are you pregnant today?
No.
Is there any possibility of you and Mr. Boubier reconciling?
No, Your Honor.
Very well. I am satisfied that the proofs that there's been a breakdown in your marriage to the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood that your marriage can be preserved. I'm going to sign this judgment that my secretary typed up. And we will make arrangement for getting this emailed to the 2 of you so that you each have a copy. And I think we have your email addresses. Hold on a minute. Yes, you put those in a judgment information form. So I'm going to sign this now. I'm going to give these to my court officer. And at some point, he will scan the judgment and email a copy to both of you. Do either of you have any questions of me?
The only question I have is when we received the information, it said that our pretrial was dated today and then trial would be August 13th. Is that August 13th not necessary?
Correct. As of today, the 2 of you are divorced and there will be no need for a trial because you were able to work everything out.
Okay, thank you.
Thank you.
You're welcome. I will sign this now. Okay, Peter, their email addresses are on this form.
Okay, perfect.
And just scan and email this to them. If you have trouble with the copier, just let me know.
Thank you.
Okay, folks, you're all set. Have a good day.
You too, sir.
You too. Thank you, Your Honor.
You're welcome. Okay, let's see. No. Okay, yeah, it looks like we're ready on Macomber. I would normally do this in chambers, but it's just a hassle to shut everything down, go in there. Where you guys at? Does the trial look realistic?
Looks like Mr. McGivney's got his mute button on, Judge. Yeah, I think we've got the case resolved. Mr. McGivney and I, hey, Pat.
Morning.
Had talked on the phone yesterday, and I think we have a resolution. So I guess I was under the impression that Mr. McGivney's client may complete his pro-con today. And then
okay.
Court could just give us a status conference in a few weeks. We'll try to get the judgment entered.
Can do it.
Call the case and give me the attorneys, please.
That's correct, Your Honor. I believe we have all the
Okay.
issues resolved, and it's just a matter of getting it on paper. And I believe a pro-con, if you're have time this morning, we can get that on the record.
Fair enough. So this is Macomber versus Macomber. Michael Fallahy for the defendant, Patrick McGivney for the plaintiff. Ms. Macomber is present. We'll take some proofs from her. Ms. Macomber, can you hear me?
Yes, I can.
Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your full name for the record.
Amy Catherine McCumber.
Go ahead, Mr. McGivney.
Your Honor, Mr. McComber is my client. He should be on the line here. Mr. McComber is.
I'm so sorry. I see that now. So sorry about that. Let me see. All right, I don't know which one of these is him. I've got an unknown. I've got a 7845094. I've got a Galaxy S9, and I got an iPhone. Oh, I'm sorry, I've got an HP too. I guess I'll work my way through them and figure out which one it is. So you look familiar?
Is that you, Mr. McComber?
Yep.
Yeah, there you go.
What do you know? We got lucky. Sir, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your full name for the record.
Aaron McCumber.
Go ahead, Mr. McGivney.
Mr. McCumber, you came to my office and signed a complaint for divorce on or about January 22nd of this year. Is that correct?
Yes.
And prior to signing that complaint for divorce, were you a resident of the state of Michigan for 6 months and a resident of the county of Jackson for at least 10 days?
Yes.
And you've alleged that there's been a breakdown of the marriage relationship to the extent that the bonds of matrimony can no longer be met. Is that correct?
Yes.
And to your knowledge, is Ms. McComber currently pregnant?
No.
And there's 2 children born of this marriage. Colin born on October 31st, 2002, and Victoria born on 11/29/2004. Is that correct?
Yes.
Any other children born or adopted of this marriage?
No.
Now, if Judge LaFlamme failed to grant you a divorce, would you go back to living as husband and wife with Ms. McComber?
No.
No further questions, Your Honor.
Ms. McCumber, can you confirm that you are not pregnant?
I am not.
I am satisfied based on the proofs that there has been a breakdown in this marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. And I will grant a consent judgment of divorce upon presentment. We'll change the August 13th trial date to a status conference. No need to appear if the judgment is submitted before then. Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thanks, Amy.
Thank you.
Yes, Your Honor, I'm here.
Okay, next case up is the matter of Fitzgerald versus Gutwein. I see Ms. Fitzgerald. Do you know if Mr. Gutwein is present? I've got a bunch of unidentified participants.
I don't know.
This is a custody case, and typically what happens when the friend of the court issues a recommended order, it's issued as a proposed final order. For whatever reason, they issued it in your case as a temporary order. Are the provisions of that, neither one of you filed an objection. Are those provisions of the temporary order acceptable to you, ma'am?
I actually tried to submit an objection, but when I called the county clerk's office, they told me it was too late to mail it in.
So you do object to the temporary order?
I don't agree with 3 of the things in the order.
All right, so what I will do is I will schedule the matter for a trial. You will get a notice of it. We'll send notice out to Mr. Gutwein. You will hear from the court as to when that will be held.
Okay, thank you.
You're welcome, ma'am. Have a good day.
You too.
Pulaski Township versus Gardinic. Did I say that right?
I think so, yes.
All right, I see Mr. White, although he's muted. Oh, there he's good. And I thought I saw Mr. Gardinic. Yep, there he is. Mr. Gardinic, can you hear me?
Yes, I can.
Okay, Mr. White, this is your show cause hearing.
Thank you, Your Honor. Eric White appearing on behalf of Pulaski Township. Your Honor, I think you probably remember this case. We had taken a judgment. Mr. Gardinic had made some substantial progress, and unfortunately, the township has indicated that the property is falling into serious disrepair again, which prompted our show cause. The only thing we're looking for from Mr. Gardinic is a solid plan to get the property in compliance.
As I recall, there are lots of disabled vehicles that are part of the problem.
Yes, Your Honor.
Mr. Gardinic, do you have a plan for cleaning up your property to the township's satisfaction?
Yes, I do.
What is that plan?
Way back, before, right at Christmas time, my one truck was stolen. And when they stole the truck, they stole the batteries and battery chargers. So when the state trooper was out here, the way he was talking was I'd get my battery charger back the next day. And he's come over and give me a subpoena for the case about 3 weeks ago. I asked him about the battery charger, and he said, no, it's still evidence. And just with the weather and everything else, trying to get in virus, trying to get somebody to give me a hand moving them has been a problem. But I just sold the vehicle last night to a young kid, and he's going to come over this weekend and be a driver for me so I can finish moving them, because, I can't drive, pull and steer the other one at the same time.
So do you think you can have all of the vehicles out of there by 6 p.m. Sunday?
Most of them. Like I said, I'm still working on some of them.
Mr. White?
What about would a 14-day period, Mr. Gardnick, give you ample time? We want you to get it done, but we want to make sure you have enough time to do it. Would 14 days from today be enough for you?
How many can I keep out?
Well, theoretically 0, unless they're plated and insured. What I would suggest you do is, when you make some progress, contact Mr. Jones at the township, and he'd be happy to come out and tell you what the township thinks of the progress, and he'll work with you, certainly.
All right. I tell you, I drive around. I see a lot of houses around here with 6, 7, 8 cars around them. That's why I was wondering how many I could keep out.
Well, we're working on all these properties, so it's not just you.
Okay.
Mr. Gardinic, I'm going to order that you have all non-conforming vehicles moved within 14 days. And upon your failure to do that, absent some concession from the township, that the township has the right to enter upon your property and remove those vehicles and dispose of them. Mr. White, you'll prepare that order?
I will, Your Honor. And Mr. Gardnick, if you could stay in touch with Mr. Jones, he's at the office at Pulaski Mondays and Tuesdays. We're more than happy to work with you. We don't want to take any action. We just want some compliance.
Okay.
Okay, thank you, gentlemen.
Thank you for your time, Your Honor. Thank you.
You're welcome. Next up is Klein versus Lentz. Is Patricia Klein present?
Yes, I'm here.
784-5094.
Yes, sir.
All right, hold on a minute.
Okay.
Okay. Is Mr. Lentz present on any of these unidentified devices?
No.
Okay, so Ms. Klein, this is your motion to terminate an ex parte non-domestic personal protection order that was entered by Judge Wilson back on April 2nd. And you wish to have the court set aside this personal protection order?
Yes, I do, sir.
And you believe it's no longer necessary for your protection?
No, he's changed everything. He's got his what together, and he is my grandson, and he was involved in some stuff that he shouldn't have been in, and he's got everything worked out now, sir.
Very good. Well, I'm glad to hear that, ma'am. On your assurance that you feel safe, I am going to grant your motion, and we will terminate this PPO.
All right. he's been in trouble trying to find a job because of this. How long before it'll be terminated so that he can go out and apply for jobs?
It's terminated now. It'll take a little time for it to get down to the clerk's office.
So by the first of the week, he ought to be clear.
Yeah, this will be filed sometime today, ma'am.
All right, that's great. I appreciate your help. And,
He doesn't
have
have
a
to
good
go
day,
right at
sir.
the moment. You're welcome. You too, ma'am.
I will. Bye.
There was one in the file.
Okay.
Okay, let's see, what else we got here? We got a motion to issue a PPO. Is Joseph Fleming present in my courtroom?
Yes, that's me.
All right. Mr. Fleming, I'm going to rename this so I know who you are. I'm going to have to take a short break before I can call your case. I just wanted to make sure you were here.
Okay.
And is Priscilla Lewis present in my courtroom?
Yes, sir. Yes, sir, I'm here.
All right, hold on. I'm going to rename yours so I know who you are.
Yes, sir.
All right, and I'm going to put you both back in the waiting room, and I'll bring you out of there when it's time for me to hear your case.
Okay.
All right. And then I've got Winklepleck versus Turk. And I see you're both here. Let me get Ms. Turk in the room. All right, and this was a PPO issued by Judge McBain in my absence in favor of Mr. Winklepleck. And Ms. Turk, you wish to have the PPO terminated?
Yes.
All right, and Mr. Winklepleck, do you oppose that?
I do.
All right, I'm going to put you both back in the waiting room. I need to take a little break before I can wade into, I was just trying to make sure that it was still contested. So I'll put you back in the waiting room. We'll get with you just as quickly as I can. Mr. Lopez. And what's left? Okay, Shannon, you could take us off the record. I'm going to take a short break and then I'll come back and handle these contested matters.